what we were talking about yesterday, about the memos and so forth. So you told us about the telephone conversation with Mr. Imes, and then, yes, and then a text that you sent, we went over the different texts or emails on February the 15th.
Yes.
Okay. How long after that was it that you had any conversations with Mr. McGee?
Whatever day I told him, I did it. Probably not the day.
Okay, but you called him first. You were the first one to contact him.
Yeah.
Okay, and you discussed some of the issues that you put in the memos to the DA's office. Is that right?
No, that's not.
Okay, when you first contacted him, what did you talk about?
Well, I told him that I just, it was just learn, or after I learned something, I studied it, and then after I studied the audios of Mr.
Lucio.
Yes. And so after I studied it, I thought about it, and then I thought about it, and then I thought about it again, and then I decided to call. And then I discussed number one issue. I said, you have to do a validation experiment, because I was basically shocked that they did not do it. And so that was issue number one. And I don't think we spoke much more than that, other than I said that I have. He said, did you read the, or are you familiar with something to affect familiar with what was presented? And I said, I only heard the audio. It's very difficult to follow the audio about pictures. So I said to my best ability, I spent hours doing that. But I would like, that's the other thing, that if it is possible, and if it's fully legal, that I would like to have the report, or whatever, no report, whatever it is that's available in other form, other shape.
From Mr. Lucio's testimony.
Right. And then he mentioned report. Would you like to have a report? I said, of course. And I said, is there anything visual with computer? Because I figured out from the audio that there was. And he said, yes, there is. I said, could you get that? He said, yes. So would you like? I said, okay, fine. So, and that was pretty much the conversation.
Okay, and then did you talk to him again after that?
Yeah, we exchanged emails. So.
Okay, at any point in your conversations with him, did you talk about the things that you testified to about today, about the difference with the measurements and the vehicle being below the ground level?
Maybe at some point, but what I did not do, I did not agree to work with their expert, unless we all have experts and come to the scene and do the validation experiment.
Right.
But I said I don't consider myself to be an expert. And the main actual point is this. And I may say so, I'm not here voluntarily. I'm under subpoena. And there's a reason for that. I'm assuming. Because I just received a subpoena. So
Right.
terrified my wife. So I did not work with their expert. They were trying to establish a relationship between me and the expert code and so on. But I said, we don't have an independent European court. We have an independent expert who works for the judge, which I would much prefer.
So would I.
Okay, but unfortunately we don't have that.
Right.
So, but then we had a couple of things, and I think Mr. McGee asked me, could you please list what you disagree with, or Mr. Jacob, Mr. Gerard.
Okay.
And I said, before that, let's just do an experiment. And so on, and then I got slapped with subpoena. Okay? And after
By
that.
the defense?
Yes.
Okay.
And then at some point we had a few changes, but that was after I already sent that stuff.
The stuff that you testified to today?
Yeah, method of rigid constraints. That opened up this whole conversation.
When did you send that to them?
I checked, I think April something.
Okay,
The report, the white paper?
Yeah, the white paper.
Yes.
And I sent it, I may say so, they didn't know I'm going to send it. They didn't know anything about it. I didn't tell anybody I'm thinking of it. Because I started working on it after I learned, no, I thought about the method. Nobody has the right to tell me not to think.
Yes.
This is no Soviet Union, so, which I'm very familiar with. But I did not physically work on the actual case and data. I was thinking about the method. And once I found out all these things and about this testimony of the other expert and what he did or didn't do, and I looked at the report and all this, then I said, okay, let's just take all this data and pump this data to my new method that I already dreamed out. And at that point, it opened conversation. And then I sent, by the way, the report on the same day, same night. It was, I think, midnight or something crazy like this. I sent it to Mr. Ives and Mr. McGee at the same time. There was no lapse between them. Neither of them knew what it was about or what it was.
and that was sometime in April.
Yeah, something.
Okay, very good. Anything on that issue?
Yes. Dr. Bruno, is it true that when we had conversations, I kept trying to get you to summarize the problems you had or the information you gave to the district attorney, and you were always reluctant to give me that information?
Yes, I wanted you to do the right thing, which is to do the experiment.
So you wanted me to do the experiment you mentioned, which is the taking the truck out to the neighborhood and do a reprojection with that camera
Yes.
and the truck in the neighborhood and compare it to the video, surveillance video.
Yes.
And every time I ask, but what did you tell them? You're like, we need to do the experiment. I'm not going to tell you the other information.
You were getting very angry.
And then I asked you also to write it down, and you didn't want to do that either.
I refused.
But ultimately, that was in the white paper that you gave him, yes?
Well, the white paper, no, white paper has a summary of that consistency. Yes,
Right,
exactly.
okay.
The part he testified.
Yeah.
He didn't even know he didn't know anything about it.
No, I understand that, yeah,
Right.
okay.
And at that point, I said why I'm doing that, because he obviously has relevance to the case, right?
Okay,
And the details that you expressed yesterday afternoon, you did not give to me beforehand.
Which particular detail?
The details about the information in like the text and all that information that you shared with the court yesterday.
No, I didn't, I don't know, that's, no. I didn't know I could do actually that.
And I think you were concerned at some point of getting sued if you're sharing information. Did you express that at some point?
I may have asked you an attorney, and I ask attorneys, can I get sued?
Yeah. Nothing further on that.
getting on people. Okay, thank you. You can step down. You'll be back after the break, but
And just for,
Can I just be here?
yeah, if you want to stay here, that's fine. If you want to,
and just for judicial notice, that the date that Mr. Licio first testified was March 12th. I looked it up. And so it was some point after March 12th we started testifying in the context.
sure. Okay. So, Mr. McGee, you indicated this morning that you wanted to be heard on some remedy or sanction for the failure to provide what is exhibit, I think it's exhibit O. So, yes, go ahead.
I believe Mr. Moline is going to address that.
You are considering the importance of the truck vehicle matching up to Mr. Merrick's property video. We've had considerable testimony about it, considering its importance to the case and its importance to the defense, and considering what the jury's importance they placed on it by asking for a viewing of it. The failure of this prosecution team to turn over Exhibit O, which we believe was, and the court agreed, which was clearly exculpatory, knowing, all the more egregious was knowing the prosecution team knew that we were going to have this hearing and still withheld that information from the court, from everyone. Had Dr. Rubin not mentioned it was on his phone, we would have never got that either. So the conduct of not only Mr. Hines, but all the prosecutors in this case, because we believe that they all know what's going on, is can only be described as reprehensible. There's no other way to describe it. They're seeking the death penalty. They're seeking to execute our client on a marginally thin circumstantial case where these things, such as whether or not the truck, Mr. Merrick's truck or not, are vitally important. So, based on that type of conduct, Your Honor, and I understand the court said that the prejudicial nature of it has waned because of the fact that it's been caught before the end of the trial. And to some degree, I agree with the court. However, Mr. McGee brought up a good point yesterday, which is Dr. Licio, cross-examination would have gone a whole heck of a lot different if we would have had this information at the time. And I do believe that Mr. Merrick was prejudiced by that lack of information. So in light of that, we are requesting the dismissal of all charges. Alternatively, a mistrial, because in reality, if this was post-conviction, then the remedy for Brady violations is reversal. Alternatively, I think that jury instruction is appropriate. At a very minimum, Mr. Hines should be removed from this case, if not all the prosecutors, all three of them. And we're asking for Dr. Licio's testimony to be stricken and not to be considered by the jury. And for future, or sometime in the future, we would like a hearing on the involvement of the other prosecutors as to their role in holding that violation. And to add to it, just for the record, that by withholding that information, they made the playing field unlevel. They made it unfair, which denied our client the Enforcement Amendment due process rights. They created an atmosphere of unfairness, and in light of the fact that they are prosecutors, they made a mockery of it. And if the court doesn't censure that type of activity, the prosecutors are going to believe that they can come into court and do this type of activity without any fear of repercussion. And that simply can't be. So,
There's one legal issue I want to state is that on the Brady violation post-conviction, the court is to review it to the standard of would it have made a difference or would it have changed the verdict when the Brady violation is discovered before a conviction. That part of the equation is disregarded. So that whether or not it changes the verdict of the jury is not part of the consideration. It's just whether or not there's a violation. So,
People wish to hear.
Well, we've addressed the bulk of those arguments in the brief, Your Honor. The people's position is, as stated by Mr. Ross yesterday. I disagree with the court's assessment of the text message and its difference from the layperson's view of what was provided to the defense. They had that information on February 15th. It was apparent from that email that Dr. Rudin was changing his testimony or at least changing his opinion or asking questions. And they were invited at that point to consult with Mr. Rudin. They didn't do so. Again, we are dealing with very complex, convoluted information that the text messages I read, I barely understand. And the first of all, the remedy is certainly not dismissal. The remedy is certainly none of the other, certainly not recusal, because that's not appropriate law notice or anything else in this jury. If there is any prejudice, as they claim there is, and we don't believe there is, we'd be happy to get hold of Mr. Liscio and bring it back down for further cross-examination. I don't believe at this point there is prejudice. I do think, I certainly don't think there's suppression. If this was an intentional withholding of information, why did we let them know at all? That we weren't going to call him, that his opinion had changed, he's unable to validate the data. Why would anyone let him know at all? There's no evidence at this point. Mr. Hines is preparing a declaration for the court. There's no evidence at this point. Well, we know the text. We don't know the text was read or anything else. And I don't know. Mr. Hines is going to prepare a declaration for the court. But there's been no suppression. And as cited in our brief filed yesterday,
I read the brief.
Okay.
And
evidence presented at trial is not considered
and the
suppressed.
Morrison case, Supreme Court decision.
Right. That's exactly right. So there's been no suppression, there's no prejudice. If the court believes there is prejudice based on counsel's argument, again, we'll be happy to check with Mr. Lucio and happy to fly it back here for further cross-examination.
So, Mr. Merrick, you understand what a mistrial is? So if the court were to grant a mistrial, that means this jury would be dismissed, excused, and the case would be reset for trial within 60 days. If your attorneys are ready to start trial in 60 days, then that's fine. We would start trial within 60 days. If they were not ready to start trial within 60 days, then it might be longer before your trial would start again. So you understand that's what Mr. Mooney is requesting that we do.
Yes, I understand.
And are you joining in that request? Okay. All right. I read the Morrison case, which is Cal Supreme Court decision 34, Cal 4, 698. And it points out several, I think, important points. Number one, the Brady requirements of the prosecution to provide to the defense exculpatory information. The purpose of that is for the defense to have that information. The purpose of that is not just a ritualistic requirement that needs to be checked off whether or not the defense already has that information. And so the Supreme Court first says the prosecution has no duty to conduct a defendant's investigation. Brady's purpose is to prevent the prosecution's ability to suppress evidence, not to provide the accused a right to criminal discovery. Brady does not displace the adversary system as the primary means to discover the truth, and the defense has the obligation to follow up and obtain information when they have information that there's other information to obtain. So when information is available to the defense at the time of trial or here during trial, there is no Brady claims for the prosecution's failure to provide that, because if the defense has the information, they're free to follow up and get that information. More importantly, the critical aspects of Brady have to do with whether or not evidence potentially exculpatory evidence is suppressed. And on that issue, the Supreme Court in Morrison said, evidence is not suppressed if the defendant has access to the evidence. They said prior to trial. Here it would be during trial, with the exercise of due diligence by the defense. And then they go on to say, in any event, evidence that is presented at trial is not considered suppressed, regardless of whether or not it had previously been disclosed during discovery. So here, the first indication that Dr. Rudin had changed his opinion or felt there was a potential problem with his opinion was on February 13th or 14th in the telephone conversations with Mr. Ines. Mr. Ines fulfilled his Brady obligations at that point by almost immediately informing the defense that Dr. Rudin had done, number one, Dr. Rudin had continued to do further work on the issue since his testimony at the 402 hearing. That number two, Dr. Rudin's opinions and conclusions changed that he was informed, Mr. Ines informed the defense that Dr. Rudin indicated that he was unable to validate the overall length of the truck compared to the known Faro scan length of the truck. Therefore, indicating that the length of the truck in the video was different than the length of Mr. Merrick's truck, which would certainly be a factor which would suggest exclusion of Mr. Merrick's truck. And that those measurements did not match. Mr. Ines also informed the defense that in addition to that measurement issue, which Dr. Rudin indicated, referenced the issue of the truck being, when it was placed by the software in a position where it could match up with the video, that it actually placed the truck below ground level in order to make that match. In addition to that issue, Mr. Ines also informed the defense that there was, Dr. Rudin indicated there was a problem with the pixel space regarding the Dodge truck, and Mr. Ines said he did not know the effect of that on the validity of the data. And then Mr. Ines said, I only have a rudimentary understanding of this, so I'm not the best conduit of all of that information. Therefore, you should feel free to contact Dr. Rudin if you want this explained further. And P.S., we're not going to use him in our case in chief, which is certainly an indication that his opinion had changed. We may only use him in rebuttal. So at that point, the defense is on notice that Dr. Rudin had, number one, done additional work, number two, had changed his opinion, number three, that the change of opinion indicated that Mr. Merrick's truck would likely be excluded as the truck in the video due to the length of the truck not matching. So the defense then had that information. They were free to follow up on that. They were free to contact Dr. Rudin, and in fact, there was contact. Once Dr. Rudin indicated, I'm a little reluctant to go into full details with you and give you everything, the defense could have and should have requested the hearing that they requested on May 16th or May 20th or 21st, to have this hearing with Dr. Rudin to say, what else is there? And the reality is, they obviously did obtain all of that information and have Dr. Rudin testifying to it. So, in terms of, is there any prejudice? I don't see any prejudice. Was any evidence suppressed? No, the evidence was not suppressed. The defense had access to that information prior to resting their case, prior to really shortly after they began their case. They had ample opportunity to present it and did present it. That, in my mind, still does not change the fact that Exhibit O, the more detailed text message, was number one, still exculpatory, and number two, should have been provided. But again, there was no suppression of information because the defense was already on notice that there was additional work and a change of opinion. So while it still should have been provided, there was no suppression, and in the court's view, there was no prejudice. Therefore, the motion for mistrial is denied. The motion to recuse Mr. Himes or any other prosecutors is denied. The motion to strike Mr. Liscio's testimony is denied. And if I didn't cover any of the other requests, those are denied as well on the grounds that there was no suppression of evidence and no prejudice.
What about the reopen request of 306 for late discovery, since they did not provide this stuff in a timely manner as required, and we're getting it now? Well, yes, there'd be no suppression to the Morris sentence case, since we still have presented evidence. It was not provided timely. It was information they should have gave over to the court to say, and based on what the court's ruling is now the people just have to say, there might be evidence out there, you have to go find it. We don't know what's different because we're not going to require, as Mr. Himes said, I don't have to make my experts write reports. And so we don't know what his original testimony is. Now there's changes, and you got to go figure out what those changes are. But you don't know what the earlier problems were before. So, could you please stop talking while I'm speaking, please?
I can speak scope, sir, thank you.
So, they now only do not supply the discovery requirement. Of course, that's okay. They don't do a timely disclosure of anything they're going to do in this trial. Of course, that's okay. We find out that an expert who has no report has changed his opinion. That's okay. Then they find out that, oh, he's actually given more written detail, the first written detail ever provided in this case, and they keep it and don't provide it, but that's okay too. Because the defense knew there was an issue. That in no way is giving my client notice of the evidence against him, the problems in the case, or any fair trial. I mean, to think that there is no suppression and no prejudice and no violation is perplexing and just amazing to think that this is the state of capital prosecution in California. That you do not have to give notice of what experts are going to testify about stuff that is so convoluted that the DA who's calling the witness does not understand it by his own admission in email. But I don't have to have him write it down so you may have a chance to understand. Or you can present that report to an expert so you guys can take a month, a year, 2 years to go through it in detail. None of that was given, that opportunity was given to the defense. We have to react on, oh, they're going to testify today. Here, we're going to do a 402 this morning so they can tell you what they're going to say. We're going to call him in the afternoon. Oh, he's not available, so we'll call him later, but you can figure it out. Or, oh, here's the report. We're going to call him Monday. If you want a continuance to look at it, that's fine. We're going to continue the trial while that's going on. So you can do your cross later while you're working with other witnesses. That's not realistically a defense's opportunity to solicit defense experts, to review that information, to absorb that information, to consider how it impacts the overall strategy of the case, and how you want to present a defense or contradict, or see what positive things can be found in that report without the assistance of other people. And that is what has happened in People versus Charles Merritt. It is a shell game. It is, we don't have evidence, so let's just keep throwing all these theories out there. Let's call these witnesses that we didn't talk to before we started opening. Let's start investigating
I
after.
think you're going far beyond the issue of the one text message with Dr. Rubin.
No, because it's the totality of circumstances. In prosecutorial misconduct, you have to look at the whole thing. You have to look at everything they've done. And that is the problem. This is a culmination of everything, and this is just the one incident we know about. Is there other information out there? We don't know. I'm sure if they send us an email and say, hey, there might be other information, you can contact our expert, which Mr. Imes has done before, and says, yeah, you are free to call my expert and get whatever information you wanted from him. That was their satisfaction under 1054.1. That was their response to every time we made a complaint about this. Well, you do our job. I'm sorry. I've done this now for over 17 years. Never have I heard of a prosecutor saying, defense, you go figure out my case and go talk to the witnesses that will refuse to talk to you. If we make an appointment to talk to somebody at the sheriff's department, we were denied access, or a DA shows up, as they did with Suzanne Anderson, and says, you're not going to have any conversation with Ebony. When we tried to have a conversation with Mr. Bruden before he called on the 402 hearing, the judge said, go and talk to him personally. Mr. Imes would not leave the room. You're not having a conversation without me present.
That's a lie.
Yes, it is. Very true.
Yes, it is a lie.
Very true.
You lie.
All right.
You're already shown to be a liar, so let's not go down there. We said,
Mr. McGee,
Wait.
Mr. McGee, if you have comments on a legal argument regarding Mr. Rubin, you can address them to the court. If you want to argue with Mr. Imes, go out in the parking lot.
I understand, I apologize, and I apologize to Mr. Imes. What I can say is when we went in to talk to him, and Mr. Moline said, can you please leave so we can have a conversation with him? He said, no. And I said, we want to have a conversation with him. He asked Mr. Rubin, do you want me to leave or do you want me to stay? He said, do I need an attorney to have this conversation? He goes, I don't know, do you want me here? Yes, then I'm not leaving. And we said, fine, then we're not talking to him. That is what happened. God forbid I have a good memory about this stuff. So we did not get to have the opportunity to talk to him. As we expressed here, if we tried to, when he contacted me, and I tried to get information from him, he wouldn't provide it. So the onus on the defense to get discovery from witnesses who don't want to cooperate with defense is a ridiculous discovery standard. And that's if this was a DUI. With this being a capital case, that should never be allowed to happen. And that is what's happening in this case. And it's very disappointing for somebody who believes in the justice system to think this is acceptable, this is okay.
And just to add, I have to add one thing, Your Honor. The court has been, and I appreciate the court giving us the time to make this argument, but we think it's important. But the court has been very clear about defense following court's instructions. The court admonished me in front of the jury without so much as a warning. Admonished me in front of the jury in very no uncertain terms. And deservedly so. Okay. However, it's interesting how the court, in such a serious issue that we believe, in regards to Exhibit O, has taken almost a role as their supporter, as their advocate. The court's ruling is the argument of an advocate for the district attorney. That's the way we see it. There's zero sanction for this prosecutor not turning over Exhibit O. In light of the history, this is not a case where we got a report in advance where we could decipher what was going on. This was on the fly. Dr. Rudin look at the dates of these emails and the text messages. It's well after we started trial. We opening statements were January 7th. These emails are February 14th and before, and 15th. Which, by the way, we never got the February 15th email as well. They said they were going to provide proof. They sent it. Well, of course they haven't, because we never got it. That's another February 15th email. It's another document that we haven't received. So you can understand our position. We don't just have these prosecutors who have proven time and time again, whether the court looks up or not, sees them on a daily basis, not just with once a day or twice a day, with almost every question that the defense asks of any witness, whether it's their witness or our witness, is met with scoffs, laughter, with eyes rolling, with whatever. If the court ever chooses to look at them, that's what you will see. But it doesn't matter. We go forward. We've made our record on those issues. It's almost like when there's an egregious violation, like we've seen with Exhibit O. Mr. Ines knows full well what he was doing. This was something he knew absolutely 100%. He was withholding this information from us. I think is reprehensible. It's the only way to describe the conduct. And for the court to act as their advocate on this issue is very disappointing. It puts us in a position where, how are we going to get a fair trial? How is it possible to get a fair trial when the court is acting as the advocate and looking for ways to justify what they've done? It's disappointing at best, and at worst, it's a violation of our client's constitutional rights, which justifies the remedies that I requested.
All right. Well, as I indicated, the information with regard to Dr. Rudin first surfaced after his testimony 402 hearing, February 14th and 15th. There was an initial disclosure to the defense. By mid or late March, the defense had already indicated they were calling Dr. Rudin as their witness. In fact, Dr. Rudin was scheduled to testify for the defense on maybe around April 23rd. That's when Mr. McGee became ill. There was Mr. Moline asked for a few days to prepare to present Dr. Rudin's testimony, or gave Mr. Moline that time. Then there was a request to wait additional time for Mr. McGee. The court granted that. And the request for this 402 hearing didn't come until the day that Dr. Rudin appeared to testify yesterday, May 21st. So, as I said, Exhibit O the text message still should have been disclosed. But given that there was no suppression of the evidence and that the defense obtained the underlying information and was able to present it with no suppression and no prejudice, court exercises its discretion not to give a jury instruction with regard to late discovery,
Can I just clarify a couple issues?
if you must.
I'm not being paid six figures for the documentary, so I'll be brief.
Your Honor? Again, we
Uh,
make an objection to that attack on the
Just
defense.
Go
And ask
ahead,
that he be
just
admonished.
state what it is you want to
One
say.
of the big issues, and this is for one of the big issues that certainly the court brought up yesterday with regard to the text message is the wheels being positioned below the level of the ground in a certain zip. At the 402, the question, page 3709, I'm sorry, 3694, actually questioned
This is yesterday or the February?
February.
Okay.
Additionally, the length of the truck and the percentage of rejection or what's a good percentage would be at 3709. He was also cross-examined on that point. So to pretend they're blind to all this is baffling. I'm not going to cast stones on the violations of the court's orders. I don't need to. I would ask for a finding of no conduct as to every member of the process, no misconduct as to every member of the prosecution.
Well, as I said, I think Exhibit O still should have been provided. It was apparently not provided.
Well, if you're assuming it was received in red,
Have to take the stand. Let's cross-examine him.
he's preparing a declaration.
Under oath.
He wanted a hearing, Your Honor. I think that's appropriate. I think we should put him on the stand and let him have his hearing.
Well, we're not going to do that now. We're not going to interrupt Dr. Rubin's testimony, but I'm certainly going to do that.
And Your Honor, it's also a violation, as the court is aware, a violation of Penal Code 141. We believe that this prosecutor committed a felony, and that's why I believe that his refusal is necessary at this time.
I already ruled on that motion.
I understand.
And just so we're clear, Your Honor, if there's going to be any hearing with testimony from Mr. Imes, we do have Mr. Rudin in his phone who has an iPhone, and that text goes out. It, I believe, shows if it's received on his phone, so maybe we can clarify that issue before he leaves today, so the record is clear, so he doesn't have to come back.
Perhaps if Mr. McGee listened to the testimony, Mr. Dr. Rudin testified that he was texting a non-iPhone person, so he couldn't tell if it was red or not.
I didn't say read, I said received. He didn't listen.
Well, you can talk with Dr. Rubin during the break, and if there's something you want to bring out on that issue, we can do it before he leaves outside the presence of the jury. It will give our court staff an opportunity to have a 10-minute break.
Also, Your Honor?